Welcome back to the RG Limited Boardroom. Pour yourself a glass of something that costs more than a modest car because today we're entering the sterilized yet surprisingly messy world of medical litigation. We are looking at two cases involving Dr. Vindhya Pathirana and the Cradle Health Specialty Center. Now, here some of you might know Dr. Vindhya personally, but in this boardroom, we don't do friendship discounts when it comes to legal analysis. We do cold, hard facts with a side of high society drama. Here is your briefing on the Cradle Chronicles, served with the signature Oksana Rabbit's Edge. The prelude, The Doctor in the Shadows. Before we even get to the patients, let's talk about the real scandal. In the RG Limited boardroom, we value a valid license. Dr. Vindhya was officially suspended by the Medical Council of Tanganyika (MCT) from January 2024 until January 2026 for a series of professional mishaps, including prescribing the wrong dose. But did that stop her? Apparently, she felt the call of duty was louder than the legal order, continuing to see patients with her license effectively suspended, and it was just a paperweight. Case 1. The jurisdiction waltz, Mamzola versus Cradle, as they say in Tanzania, but we say Mamzola and Cradle. First up, we have the Halima Mwamzola case. This was a 500 million shilling claim for medical negligence. The defense lawyers tried a move I usually reserve for hostile takeovers, the preliminary objection. They argued the High Court didn't have pecuniary jurisdiction because the specific damages only totaled around 175 million Tanzania shillings, below the High Court's 200 million shillings threshold. But the judge wasn't playing games here. In the rare moments of judicial efficiency, the court ruled that while the numbers might be small, the interest of justice demanded the High Court keep the case rather than tossing it back to a lower court to start all over again. Case 2. A 1.5 billion shillings tragedy, Bay Ghana and Cradle. Now let's talk about Juliet Felix Begana. This is the stuff of actual nightmares. A 50-year-old woman, a successful IVF procedure in Nairobi, and twins on the way, her precious babies. She arrived at Cradle in February 2024, leaking water. What followed was a legal and medical car wreck. One twin was born naturally, the other by a C-section performed by Dr. Vindhya. Both babies were premature. The horror? Cradle allegedly didn't have the facilities to care for them, and they spent hours waiting for an ambulance. Tragically, both babies eventually passed away. The boardroom verdict, negligence versus misconduct. Here is the twist that will have the lawyers talking for years. Juliet sued for 1.5 billion Tanzania shillings, but the court found that medical negligence wasn't strictly proven because the plaintiff didn't bring in a competing expert or a death certificate that pinned the case of death directly on the doctor's hands. However, but the court ruled that Dr. Vindhya and Cradle breached their statutory duty by treating a patient while under suspension. It was a psychological torture to find out your doctor was banned while she was operating on you. The result? A 15 million shilling judgment for general damages plus 12% interest. So, my final take here, darlings, the lesson from the Cradle files is simple. Check the wall for certificates before you let them pick up the scalpel and operate on you. Okay. In the RJ Limited boardroom, we know that you can be the most skilled person in the room. But if your license is suspended, you are just an expensive liability. Dr. Vindia might have wanted to save lives, but in the eyes of the law, she was just tampering with a guinea pig. Now, if you'll excuse me, I need to go audit the medical credentials of my personal trainer. I don't do suspended, and I certainly don't do peripheral facilities.